Good evening. Good evening and welcome. My name is Albert Thames and as Director of the School of Journalism and Mass Communication here at the University of Minnesota, it's my privilege to welcome you to the 24th Annual Silha Lecture. The Silha Lecture is made possible by a generous endowment gift by Otto and Helen Silha and their family. We're fortunate this evening to have a number of the Silha family members here with us, and so if you folks don't mind, at least turn around and raise your hands. We have Helen Silha here. Next to her, her granddaughter Sarah, Alice Ryman, and Steve Silha. So we want to thank them for their generosity. In addition to this lecture, the Silha Endowment also funds the Silha Center for the Study of Media, Ethics, and Law in the School of Journalism and Mass Communication, a center that does very important work related to media and law. And it funds a wonderful endowed professorship, the Silha Professorship for the Study of Media, Ethics, and Law, a position held by Professor Jane Kirtley, which I will introduce here in just a moment. It's at this point that I would like to introduce Jane Kirtley, who will introduce our Silha lecture for this evening. So, Jane.
Good evening. You are about to meet a member of an endangered species. Siobhain Butterworth is the reader's editor, the ombudsman for the Guardian newspaper in London. Many of you are probably very familiar with The Guardian. It is an independent newspaper founded in 1821 that proudly describes itself as liberal. The innovative Guardian Unlimited network of websites, which was launched in January 1999, is the second largest news destination in the United Kingdom after BBC News Online. You may be one of the more than 4 million visitors from the United States who log on to one of the Guardian sites every month. Siobhain Butterworth is an attorney and provided legal advice to The Guardian and its sister publication, The Observer, for about 10 years before becoming the reader's representative in April of 2007. Her job is to investigate and respond to readers' questions and complaints about The Guardian's print and online editions. She also writes a weekly commentary and considers items for the daily corrections and clarifications column at The Guardian. But she is one of a vanishing breed. Until fairly recently, nearly 30 newspapers in the United States had ombudsmen. But as Editor and Publisher magazine reported last week, approximately 10 of those newspapers have dropped their ombudsman in the past 12 months. This includes the Sacramento Bee, the Baltimore Sun, the Fort Worth Star-Telegram, the Orlando Sentinel, the Hartford Courant, the Palm Beach Post, and the Minneapolis Star-Tribune. Most of these newspapers would say that because of economic downturns, they can no longer afford to have an ombudsman on their staff. But as the so-called legacy media face greater competitive challenges from the emerging new media, both bloggers and other kinds of online journalists, while at the same time attracting increasing criticism and attacks on their credibility and accountability from both the right and the left, the question I would ask is, how can they afford not to have an ombudsman? To help us answer these and many other questions, it's my pleasure to introduce our annual Silha lecturer, Siobhain Butterworth.
Well, thank you, Jane, and thank you to Helen Silha, the Silha family, and the Silha Centre for inviting me to deliver the 23rd annual lecture. I'm delighted to be here. You hear a lot about the need for transparency, openness, and accountability these days. There's a lot of talk about trust and confidence too. We've heard these words plenty of times in discussions about the future of the banking system in the last couple of weeks. We're also used to hearing them in conversations about the future of journalism, or at least I am. In fact, I hear them so often, I worry that they're beginning to lose their impact. I deliberately avoided employing them in the title to this lecture because I feel that I perhaps overuse them myself. Nevertheless, these words and ideas are inescapably the underlying themes of this lecture. The title, Raise Your Hand If You're a Journalist, Does Responsible Reporting Need a Legal Defence?, invites discussion of a number of issues. Here are the 5 I'm going to talk about tonight. Can we agree on what constitutes responsible journalism? Can we agree on who is a journalist in the digital age? Why should journalists be prepared to own up to their own mistakes? If journalists are acting responsibly and owning up to their own mistakes, do they need legal defences? And finally, what legal defences are available for responsible reporting? Along the way, I'm going to tell you a bit about The Guardian, and I'll explain where the role of the internal newspaper ombudsman as a form of self-regulation fits in with concepts of responsible journalism. I want to start by looking at different perspectives on the subject of responsible journalism. First, the judicial perspectives. What does responsible journalism look like to judges? Well, it depends which side of the Atlantic the judge is on. In New York Times and Sullivan, decided in 1964, the US Supreme Court, focusing more, it has to be said, on irresponsible journalism than defining responsible journalism, held that damages cannot be awarded to a public official for a false and defamatory statement relating to his official conduct unless he proves actual malice, which requires him to establish with sufficient clarity that the journalist made the statement with knowledge of its falsity or with reckless disregard of whether it was true or false. 35 years later, the House of Lords, in the case of Reynolds and Times newspapers, decided to take a different approach to the problem of providing media defendants with a defence that gives them the right to get things wrong in certain circumstances. The House of Lords, for those of you who are not familiar with the UK legal system, is the final court of appeal in the UK. In the Reynolds case, the House of Lords decided that a media defendant may have the right to get something wrong if it has acted responsibly. In his leading judgment, Lord Nichols provides a list of 10 factors, known as the Nichols Factors, to be taken into account by the court when it is deciding whether the standard of responsible journalism has been met. Here they are. 1, the seriousness of the allegation. The more serious the charge, Lord Nichols said, the more the public is misinformed and the individual harmed if the allegation is not true. Secondly, the nature of the information and the extent to which the subject matter is a matter of public interest. Thirdly, the source of information. Some informants have no direct knowledge of the events, Lord Nichols said. Some have their own access to grind or are being paid for their stories. Fourthly, the steps taken to verify the information. Fifthly, the status of the information. The allegation, Lord Nichols said, may have already been the subject of an investigation that commands respect. 6, the urgency of the matter. News is often a perishable commodity, Lord Nichols said. 7, whether comment was sought from the plaintiff. He may have information others do not possess or have not disclosed. An approach to the plaintiff will not always be necessary. 8, whether the article contains the gist of the plaintiff's story. 9, the tone of the article. A newspaper, Lord Nichols said, can raise queries or call for an investigation. It need not adopt allegations as statements of fact. Finally, the circumstances of the publication, including the timing. Now, Lord Nichols made a point of saying that the list was not intended to be exhaustive, and he said that the weight to be given to these and any other factors would vary from case to case. But I'm sure you won't be surprised to hear that this part of the judgment was more or less ignored, and that very few defences of responsible journalism succeeded in the next 7 years. The problem, as Lord Hoffman noted in the House of Lords judgment in the Wall Street Journal case in 2006, was that the Nichols Factors can be seen by judges as a test which a publication has to pass. And in Lord Hoffman's words, they can become 10 hurdles, at any of which the defence may fail. Let's take a look now at how some journalists have defined responsible journalism. US authors Kovach and Rosenstiel offer a description of the elements of journalism in their book of the same name. Coincidentally, it's another list of 10 factors. The primary purpose of journalism, say Kovach and Rosenstiel, is to provide people with the information they need to be free and self-governing. And the 10 elements of journalism needed to fulfill that task are as follows. Journalism's first obligation is to the truth. Its first loyalty is to citizens. Its essence is a discipline of verification. Its practitioners must maintain an independence from those they cover. It must serve as an independent monitor of power. It must provide a forum for public criticism and compromise. It must strive to make significant, interesting, and it must strive to make the significant, interesting, and relevant. It must keep the news comprehensive and in proportion. Its practitioners have an obligation to exercise personal conscience. And finally, they said citizens too have rights and responsibilities when it comes to the news. A completely different approach to responsible journalism was set out in an essay written by C.P. Scott in 1921 to celebrate the centenary of The Guardian. By this time, Scott had been editor of The Guardian, or Manchester Guardian as it was then known, for 50 years. A newspaper's primary office is the gathering of news, he said. At the peril of its soul, it must see that the supply is not tainted, neither in what it gives nor in what it does not give, nor in the mode of presentation must the unclouded face of truth suffer wrong. He went on to provide what has become something of a mantra for Guardian journalists. Comment is free, but facts are sacred. Indeed, The Guardian took this statement, or one half of it, as the name for its comment is free blog, The Guardian's version of the Huffington Post. The next bit of C.P. Scott's centenary essay can be found today under the heading Fairness in The Guardian's editorial code. The voice of opponents, no less than that of friends, has a right to be heard. It is well to be frank. It is even better to be fair. The values expressed by C.P. Scott underpin the standards The Guardian sets for itself today. The Guardian's liberal journalism has a wide appeal both inside and outside the UK. It might be seen as part of what Geneva Overholser called, when she gave this lecture 4 years ago, the invasion of the British media. If there has been a British invasion, the web has been the Trojan horse. The Guardian, which is currently the UK's most popular online news site, attracted more than 23 million unique users in August, and only around 8 million of those were UK users. All news organisations have had to recognise new competitors in the digital age. The Guardian's small pool of traditional old media competitors used to be limited to other UK newspapers. Not anymore. Its competitors now include the BBC and other broadcasters, and its website competes with sites owned by traditional old media all over the world, as well as Google, Yahoo, and countless other small and large sources of news and information. This is an era of mass self-publishing, in which monoliths compete alongside individuals, social networks, and small businesses for audiences and advertisers. What does the fact that we live in an era of mass self-publication have to do with journalism? Well, leaving aside the enormous economic impact of advertising revenues and readers migrating online, it makes journalism and responsible journalism harder to define, and sometimes that matters. Clay Shirky tells us in his book, Here Comes Everybody, that what previously defined journalism was the means of production. Whether or not someone was a journalist boiled down to an employment issue. Journalists, and by implication journalism, was easy to identify because the economic model involved relatively few publishers providing information to many people. Being able to identify journalists and journalism matters if you're trying to decide which ethical standards should be applied to different types of content, as I do in my role as The Guardian's readers editor. Here are some things to think about. Do citizens produce journalism when they submit eyewitness accounts and photographs to the BBC or CNN or The Guardian? Do journalistic standards apply to them? And if so, what are those standards? What, if any, ethical standards should be applied to user-generated content in the form of comments posted to articles and blogs? Should bloggers on The Guardian's Commenters Free website operate to the same standards of journalism as Guardian journalists, even though many wouldn't describe themselves as journalists? What about comments posted by journalists to Guardian online content? In short, should all content on a newspaper's website be treated as journalistic content? And if so, do the same journalistic standards apply across the board? You might regard these as relatively minor issues that will easily be resolved over time as codes of ethics develop, and you might be right. But it's not just a question of journalistic standards. There are also legal issues related to journalistic ethics, which may make it important to define who is a journalist and what journalism is. For example, journalists are under a moral obligation not to disclose sources of confidential information. Clay Shirky mentions the problem of defining journalists so as to frame a US federal shield law. If anyone can be a publisher, then anyone can be a journalist, he says. And if anyone can be a journalist, then journalistic privilege suddenly becomes a loophole too large to be borne by society. He goes on to say, journalistic privilege has to be applied to a minority of people in order to preserve the law's ability to uncover and prosecute wrongdoing while allowing a safety valve for investigative reporting. But he doesn't believe the solution is to exclude bloggers. The simple answer is that there is no simple answer, he says. Since we don't have a solution to this problem, let's park it and move on to the subject of why journalists should be prepared to raise their hands when they've made a mistake. The ability of journalists to go about their business of collecting and publishing information without interference is necessary to protect the free flow of information. But is a knee-jerk defence to complaints about what has been published always appropriate or even sustainable? When I very first began working for The Guardian as a lawyer more than 11 years ago, The Guardian didn't have an internal ombudsman, and it had never had an in-house lawyer. The filing cabinets were heaving with litigation. There must have been at least 50 legal cases with external lawyers. Their job was to identify whether the claimant had any kind of legal case, and then work out whether the paper had any kind of legal defence to it. This made life simple, if expensive. Corrections were resisted if there was no legal threat, and apologies were seen as a sign of weakness. Not long afterwards, under an initiative from its editor, Alan Rusbridger, The Guardian became the first British newspaper to appoint an internal ombudsman, and at the same time it instituted a daily corrections and clarifications column. In the first year, there were just over 5,000 emails, calls and letters to the Reader's Editor's office, but that number has steadily increased over the last decade. In the last 12 months, I've had more than 22,500 communications from readers and journalists about mistakes. To put that in context, the UK's Press Complaints Commission says on its website that in 2007 it had 10,000 inquiries. There have been more than 1,400 corrections in the paper's corrections and clarifications column in the last 12 months alone, and probably the same number again to online content. We don't keep a record of those. Does that make The Guardian careless or responsible? A recent Guardian reader survey suggests that correcting errors does no harm and might actually do some good. Of those who took part in it, 88% were aware that the paper has a corrections and clarifications column, and 90% of print readers, 81% of online readers, consider The Guardian's news coverage to be trustworthy. Refusing to own up to mistakes is not just an ethical issue. It's also out of kilter with the times, as the Huffington Post found in 2006 when it posted George Clooney's blog, except that, as George Clooney was quick to point out, it wasn't his blog. Just things he'd said in interviews to other news organisations, including The Guardian, that had been stitched together by the Huffington Post. The Huffington Post's initial reaction was typically and traditionally defensive old media. Here's Ariana Huffington's first response to the problem on March 15th, 2006. This was an honest misunderstanding, but any misunderstandings that occurred between Clooney and the publicists. We based our decision to post on the unambiguous approval we received in writing. There was no room for misunderstanding in that. But Huffington Post readers, commenters and bloggers were having none of it, and this is what she published 3 days later in a blog post headed Lessons Learned. I now realise that I made a big mistake in posting a blog without clearly identifying that the material in it didn't originate as a blog post, but was pieced together from previous interviews. I'm sorry I didn't see this earlier, but I see it now. She told users that in future the Huffington Post would identify repurposed material and they would source where it originally appeared and would link to it. She ended up by saying, "We've been doing this for 10 months and the learning curve has been enormous. Consider this a major lesson learned. I get it and have taken it to heart." The lesson she learned was that the web forces journalists and editors to be accountable and transparent about mistakes. Owning up is barely a choice. The Guardian has had similar experiences. In June, the website published a gallery of 5 photographs headed "Man Jumps Over Grand Canyon." One of them was used as a pixie, that's a little picture, on the homepage, and that provided a link to the gallery. They were published because a news agency sent them at around this time to the paper with a caption that claimed they showed a daredevil leap across a 1-kilometre deep ravine. And here he was, this man, in T-shirts, jeans and sandals, with a camera and a tripod under his arm, striding in midair from one piece of knobbly rock over what looked like a great chasm to another. They were wonderful pictures, but there were 2 problems with them. Firstly, they were 2 years old and had been published elsewhere on the web, though not in the mainstream media, so not exactly news. Secondly, the idea of a giant leap had been debunked. Another website, Snopes.com, had critiqued the pictures in January 2007, and a picture in the same series showed a lower edge that might have broken the fall. Web users were quick to cast doubt on the age and nature of the images by reference to these other sites. And within a few hours, the question, "But is it real?" was added by The Guardian's website to the gallery. And the website also put up a blog post asking users to share with them what they knew about the pictures. More than 40 comments were posted that day. Note that the website didn't post a note saying, "It's not our fault, we got them from a news agency, they were wrongly captioned, and we weren't told they were more than 2 years old." That would have been defensive old media. The same pictures had been used in the paper too, albeit with a different caption, and I wrote a column on the subject. Living in a digital age, in this era of mass self-publications, means that there are millions of fact-checkers out there. It also means that mistakes are amplified because journalism doesn't stay in the paper any longer. It's linked to and passed around. So the more serious the mistake, the greater the urgency to put it right. There's no excuse for correcting the record quickly when you've got something wrong. It's worth saying at this point, in case anyone gets the wrong idea, that I don't think that self-regulation is the complete answer to everything. Responsible journalism means owning up to mistakes, yes, but it can also mean fighting difficult and costly legal cases when you're right. There are historic libel victories which enhance a newspaper's reputation and enhance reader trust and confidence too. Like The Guardian's famous libel win against the Conservative government minister Jonathan Aitken in 1997, which resulted in the famous headline, "He lied and lied and lied," the day after his libel proceedings collapsed. A headline all the more sweet because when Aitken issued libel proceedings against The Guardian, he gave a press conference and made this public statement. "If it has fallen to my destiny to start a fight, to cut out the cancer of bent and twisted journalism in our country with the simple sword of truth and the trusty shield of British fair play, then so be it." He ended up in jail for perjury. He served 7 months of an 18-month sentence and bankrupt as a result of this libel action. And I think that case may have given a new definition to the word hubris. Other legal cases have to be fought too, and again, they need to be fought because there are important principles at stake, but also because they tell readers about your values and they increase reader trust and confidence. Those at the front line of the battle to maintain the free flow of information to the public are particularly important. Cases about disclosure of confidential sources, access to information, and fights about reporting restrictions. It's all hugely, hugely important stuff, but not the subject of tonight's lecture. As a media lawyer turned journalist and news ombudsman, I naturally find myself thinking a lot about the places where media law and ethics intersect. Journalism, it seems to me, doesn't operate in a vacuum, and neither does media law. Legal cases inform journalistic behaviour, and vice versa. Legal principles and ethical issues for journalists also come together because freedom of expression is a moral as well as a legal issue. In the US, it's a constitutional right. In Europe, it is a human right. As reader's editor, I consider myself under a moral and a legal obligation to place freedom of expression in the balance when a complainant asserts a competing right, such as injury to reputation. Reviews provide especially fertile grounds. I'm sorry, I should have introduced this section. I want to talk a bit now about the legal defences for responsible journalism. Reviews provide especially fertile ground for complaints, more so in the digital age. The brush-off cliché about newspapers used to be that they were tomorrow's fish and chip wrappings. But these days, thanks to the internet, newspapers' articles are more like tattoos, extremely difficult to remove. And because the web is an easily searchable repository of everything, it is an especially unforgiving medium. Should journalists, as some readers have suggested to me, be mindful of the permanent and regurgitative nature of the web when they write about people and businesses? Earlier this year, a reader complained about a restaurant review by Guardian critic Matthew Norman, which praised the food but was horrible about the decor. Among other things, Norman wrote, "This was as technically outstanding and lavish a lunch as you could expect for the money. All it needs is a wrecking ball and a designer." When reviews lead to libel actions in the UK, journalists usually claim the protection of the fair comment defence. It's a defence that should probably be renamed because the fairness bit is basically obsolete. For a comment defence to succeed, the opinion has to be one that an honest person could hold based on identifiable facts. The defence can be much less straightforward than it sounds because it's often difficult to separate out comments from facts in a review. But recently, in a case called Convery, the Northern Ireland Court of Appeal in Belfast made the sensible decision that an elaborate factual substratum is not required to support a restaurant critic's opinions about the food he or she has eaten. Opinions that have no factual basis are legally and ethically indefensible, but that does not mean nitpicking every review, as readers sometimes ask me to do, to try to separate out fact from comment. In the Convery case, one of the facts identified and disputed in the lower court was whether the Coca-Cola the critic was served was flat, and that's patently nonsensical. What the Northern Ireland Court of Appeal decided in the Convery case was that the critic's subjective experience must be viewed as part of the factual matrix, not something separate from it. I mention this case because I think it articulates ethical as well as legal considerations. A reviewer should be honest in the sense that he or she should hold the opinions expressed. But objectivity is not required or even desired. Critics tell us about their personal responses to experiences, and readers want to know what they really think. The freedom of expression issue and the public's right to know trumps all other considerations, including the impact of the review on an individual or business and the permanent and repetitive aspects of web publishing. Time and again, we see that responsible journalism does need legal protection. Comment pieces are a case in point. As the Convery case shows, you can't stop someone suing you, even if you have behaved responsibly. Investigative journalism is another area where reporters need legal protection for the simple reason that responsible journalism is not infallible. Journalists need to have the right to get things wrong in certain circumstances. I outlined earlier the two most important cases in the US and UK that provide this sort of protection, New York Times and Sullivan, and the Reynolds case. The Reynolds case provides a much narrower protection for journalists than New York Times and Sullivan, but it's still a useful shield for British journalists. As I explained at the beginning of the lecture, it was for several years difficult for newspapers to avail themselves of the defence because the lower courts had a tendency to take the Nichols Factors literally. But in 2006, the House of Lords reaffirmed and clarified the defence in the case of Wall Street Journal and Jameel. The Wall Street Journal's article reported that the Abdul Latif Jameel Company was one of a number of businesses monitored by the Saudi Arabian Monetary Authority at the request of US law enforcement agencies. The Jameels complained that readers would assume the article was suggesting that they were involved in funding terrorism. The Wall Street Journal said that this was not their intention. The point of the article was that Saudi Arabia was cooperating with the US government post 9/11, something which had been in doubt. The journal was not able to prove that what it had published was true, hence its reliance on Reynolds' privilege, but, it argued, it had done a thorough job investigating the story and had acted responsibly. When the case came before the House of Lords, the law lords said that the lower courts had been setting the bar too high for media defendants in Reynolds' cases. Baroness Hale said, "We need much more serious journalism in this country, and our defamation law should encourage rather than discourage it." She added, "If the public interest defence does not succeed on the known facts of this case, it is hard to see it ever succeeding." Lord Bingham said, "The matter published should be one of public interest. The publisher is protected if he has taken such steps as a responsible journalist would take to try and ensure that what is published is accurate and fit for publication." Lord Hoffman suggested that the defence be named the Reynolds Public Interest Defence. The House of Lords said that the newspaper should have been given credit for editorial decisions that it made in good faith before the article was published. They also said that the judgments made by editorial staff at the time of publication are relevant when deciding whether a media defendant has acted responsibly. Lord Bingham said, weight should ordinarily be given to the professional judgment of an editor or journalist in the absence of some indication that it was made in a casual, cavalier, careless, or slipshod manner. The Law Lords also said that the failure of the newspaper to get comment from the Jamils should not have been fatal to its defence, and it held that the Wall Street Journal's reliance on anonymous sources was an important and credible part of the news-gathering process. The trial judge had suggested that the article could and should have been published without naming names. The names gave credibility to the story, Lord Scott said. He also said, it is no duty of the press to cooperate with any government, let alone foreign governments, whether friendly or not, in order to keep from the public information of public interest, the disclosure of which cannot be said to be damaging to national interests. So yes, responsible journalism does need a legal defence, at least in the UK. I started out with some questions arising from the title of this lecture, and I haven't provided you with neatly packaged answers. What we know is that there is no universal standard of responsible journalism. That may always have been the case, but the digital age has brought further existential anxiety to traditional media because there's no longer consensus about what is and isn't journalism, or who is and who isn't a journalism. I wonder, though, whether this is really such a big problem for the mainstream media. The thing is, and this may sound like heresy to some of you, I'm not sure that readers, users, and audiences are as worried as some journalists are about all of this. When readers complain to me about content, by which I mean everything The Guardian produces, from traditional text and pictures to video, audio, blog posts, and user comments, they may talk about whether The Guardian has acted responsibly, particularly in relation to news stories, but they don't tend to distinguish between journalistic and non-journalistic material. More frequently, they complain that the content, whatever it is, doesn't reflect The Guardian's liberal values. This takes me back to something else C.P. Scott said in his Centenary essay about a newspaper's values. A newspaper has two sides to it. It is a business like any other and has to pay in the material sense in order to live. But it is much more than a business. It is an institution. It reflects and it influences the whole community. It may affect even wider destinies. It plays on the minds and consciousnesses of men. It may educate, stimulate, assist, or it may do the opposite. It has therefore a moral as well as a material existence, and its character and influence are in the main determined by the balance of these two forces. It may make profit or power its first object, or it may conceive itself as fulfilling a higher and more exacting function. One of the virtues, perhaps almost the chief virtue of a newspaper, is its independence. Whatever its position or character, at least it should have a soul of its own. The resources of a newspaper are not wholly measured in pounds, shillings, and pence. The Guardian is in a privileged position because it is owned by a trust. The Scott Trust was set up more than 70 years ago to maintain the principles of liberal journalism that C.P. Scott espoused, and, it must be said, to avoid death duties. It is, I think, a unique form of press ownership which gives The Guardian complete editorial freedom without having to be concerned about the whims of a conventional proprietor or the influence of shareholders. The principles of the Scott Trust were restated in 1992. It exists to secure the financial and editorial independence of The Guardian in perpetuity as a quality national newspaper without party affiliation, remaining faithful to its liberal tradition as a profit-seeking enterprise managed in an efficient and cost-effective manner. It's a commercial enterprise, but the editor and managing director of The Guardian stand level. This was another idea set out in C.P. Scott's 1921 essay. He said, editor and business manager should march hand in hand, the first, be it well understood, just an inch or two in advance. I want to end by talking about self-regulation and the role of the news ombudsman in the digital age. This year, as Jane said, several US media organisations have done away with the role, including the Louisville Courier, Hartford Courant, Sacramento Bee, USA Today, and your local paper, the Star Tribune. Kate Parry, the outgoing Star Tribune reader's editor, or reader's representative, I think she's called it a lousy decision that does not serve readers well. You can understand why this is happening. There is a cost to self-regulation, and news organisations are feeling the pinch. But isn't it odd that newspapers decline openness, transparency and scrutiny themselves while demanding it of others? In March this year, Simon Domenko wrote an article in the US journal Advertising Age, arguing that the newspaper ombudsman is obsolete. He offered 5 reasons why having a public editor at the New York Times and other papers no longer makes much sense. First, he said, readers can challenge newspaper reporting themselves, especially in the blogosphere. Secondly, media blogs deal with all the important journalistic issues. Thirdly, readers can engage directly just by emailing journalists. Fourthly, this is the one I like best, ombudsmen are boring as hell. Borderline elderly, paternal or maternal types. No offence taken, Simon. The money is better spent elsewhere is the final one. The more than 31,000 emails I've received in the 18 months since I've been reader's editor suggest otherwise. In fact, the figures show that as The Guardian's online presence has increased, so have communications to the reader's editor's office. So it seems that in the digital age, news ombudsmen are more, not less, appreciated by readers. That Guardian survey I mentioned earlier found that 62% of readers were aware of the existence of the Guardian's reader's editor, and 81% of them feel that the paper is more responsive to their views because the role exists. Thank you.
Now, we would like to invite you to join our conversation. If you will raise your hand, one of the Silha Center staff will bring a microphone to you. And in order to allow as many people to participate as possible, I would like to ask that you keep your question to Siobhain short and to the point. So, do we have questions, I hope? Yes. I'll get out of your way.
I just wanted to know what the 10th Nichols Factor was.
Okay, it was. I think it's the circumstances of the publication,
Circumstance.
including the timing.
And this has become a reliable test that all journalists use online now.
Yeah,
And The Guardian, and in the United Kingdom, and
Completely the contrary. The point I was trying to make is that judges have one particular view of what responsible journalism might be, but it might not necessarily be everyone else's cup of tea.
Thank you very much.
In the specific example that you mentioned of the restaurant review, I actually thought you were going to go somewhere quite different with that, and I was kind of surprised by the outcome. You talk about searchability and how archives stay for a long time online, but particularly right now, there are no ways to search by date. So if The Guardian has a lot of clout, they'll come up high in Google searches. So 5 years later, after a redecoration, now I realize this is a trivial example, but it could be extrapolated, that might still be the first result that comes up, and it might be no longer accurate. And I was just wondering if you could speak to the implications of that.
Sure. It took me ages and ages to arrive at that decision. It sounds, that's what we'll do. But obviously, when I am inundated by complaints like that from readers, and readers really frequently ask us to remove content from the archive. They ask us to remove their letters to the paper, even when they're anonymous letters. They ask us to remove comments that they've posted online in their own names. They ask us to remove restaurant reviews. Restaurant reviews, after all, are not particularly helpful to restaurants in lots of cases, not least because they might change hands and have completely revamped. So it is a really, really difficult thing, but I think that if I didn't weigh freedom of expression in the balance, I think that from a legal perspective, I would be interfering with freedom of expression, which wouldn't be a good thing. I think that would be a very bad thing for ombudsmen in any case. But from a moral perspective too, I think that one of the things that restaurant critics do is they offer a service. This is a service that they're offering. They're sharing their views with readers. They're very popular. Once you start deleting the material after a certain amount of time, you'll end up with huge holes in your archive, and that can't be a good thing either. So I do think it's a terribly difficult thing, but I don't think there's any way around it. The implications of going the other way are enormous. I mean, does anybody have a different view? Does anybody think that you should not produce restaurant reviews? Hopefully somebody does.
Rather than being a revisionist historian, would it be better maybe to put a disclaimer of sorts on an obsolete review or some article that is no longer valid?
At what point do you make that decision?
That's a good question.
I mean, because I get these things all the time, you do really puzzle over how, what would be the right thing to do. But once you start filtering a huge archive like that, I mean, it's such an onerous burden for newspapers.
So you never remove anything, not even...
No, we do remove content.
Oh, you do?
Do you want to know when? In fact, I was talking to the editor about this recently because the sheer number of complaints about people wanting things removed from the archive is just so enormous that it's actually slowing down the complaints problem as the complaints handling process as I consider them. So the circumstances at the moment, the idea is that the circumstances have to be exceptional. So typically, things that I would consider removing are young people who gave interviews a long time ago about things that they did on Saturday nights that they now can't get a job because of. Journalists, I don't know if it's the same in the States, but the British journalists have a habit of writing about their family life. And, especially when their kids are small, there's a lot of kind of sort of me journalism. And there was one example where a journalist wrote about her son when he was age 3, liking to dress up as a girl. And when he got to kind of school age, his friends, there's a photograph from this article in any case, but he was named, his mum was named. So when he got to school age, he was suffering quite a lot of bullying. And so sort of on compassionate grounds, you would remove something like that. Similarly, we picked up a story from the Times a while ago about a couple who had a home birth, and it was a particularly terrible experience for them. They ended up with a very severely disabled child. They were both homeopathic practitioners, and as a result, they were getting terrible hate mail from people because the Times had reported their story, as if they didn't have enough to deal with. So, we removed that content too. It is terribly difficult. I mean, it is possible to devise a completely different approach to archives and simply say, well, we'll take it out and put a note in. And sometimes, if people people unbelievably say things like, I gave an interview to the paper, but I didn't realise this was going to go online. And I think that's getting a bit thin now. But there was a point at which you could be quite sympathetic with that.
To what do you attribute your readers' familiarity with the Ombudsman? And was there any particular strategy that The Guardian employs to make readers familiar that they have an advocate with your publication?
Well, there's a daily corrections and clarifications column, and I think that really helps. I write a weekly column that's quite visible in the newspaper, but I'm not really satisfied with its visibility online. So I think those two things help. And I think it helps that Guardian readers come back, time and again to the paper, that it's not a particularly transient readership. So there's a certain sort of familiarity about it. So people sort of are very much in the rhythm of it. But my predecessor did a lot of proselytising about the role, and some of the corrections we publish are, hilarious. So they tend to sort of get around. They get into satirical magazines, and some of it's quite jolly, some of it isn't.
For the papers that are removing or that have eliminated their ombuds people domestically, how will they handle corrections? I mean, you see, tonight's lecture is the first time that I've really thought about the newspaper ombudsperson, but obviously I'm familiar with seeing corrections in newspapers. In the absence of an ombudsperson, how are those handled?
I think in this, I was reading the Star Tribune's Reader's Editor's column about this today, and I think in that case they're going to sort of devolve responsibility to sort of section editors, other editors. I mean, I wonder whether in sort of, because of the culture of the web and this idea that, you know, there is a willingness among web journalists, I think slightly more willingness among web journalists to amend content and to say, oh yeah, we made a mistake and quickly amend it. You know, I wonder whether in the very long term, a role like mine will not be obsolete, but might be more of a sort of court of appeal. You know, if the complaints have not been handled well, in other avenues, then you may still need someone there to say, well, hang on a minute, I'm still not happy. But at the moment, when we're in this transition period between old media and new media, and old media is slightly more reluctant to raise its hand, I think that it's still a very necessary function.
Can you comment on, that you mentioned earlier on direct emailing to journalists? Can you comment on how that's affected their professional practice? I
think I've spoken quite a lot. I wrote a column about online etiquette because our journalists and columnists are very much encouraged to take part in the online debate. What a lot of columnists say is it's just too hostile. You know, you won't believe the kind of things that we get from people. They're also under much more pressure to get stories out. In the case of the Lehman Brothers collapse, you know, we had a very small team of people writing full stories for the paper in the traditional way. But as the day went on, you know, by midnight they'd published 38 other pieces of content. So we had print journalists doing audio and video on the website. So, I mean, what they say about that is it's really difficult to respond to emails from readers ourselves. I mean, some people really try and do it, but it is very difficult. And the other thing is that when people email you, I mean, when I did this column on online etiquette for journalists, I did a survey in the newsroom and asked journalists, well, what do you think about this? Do you think it's okay? Because one of the journalists had been very, very rude to somebody online. And one of our most prominent columnists said to me, this is basically a very discourteous mode of communication. And people are contributing anonymously, and they say things they wouldn't say to you in a public situation. They say things they wouldn't say to you in a pub, but they feel free to be incredibly aggressive online and say things like, oh, come off it, what a load of crap, you know, you did this, you did that. So it's very, very difficult. And I get a lot of those kinds of emails myself. I got one from, I wrote a column about the London mayoral elections because the day before the elections, we published this huge spread saying, don't vote for Boris Johnson, the Conservative candidate for the election. And lots of readers said, you know, this is absolutely disgusting, we don't want you telling us how to vote. So I wrote a column about that because it's an interesting topic and because some people don't understand that the British press is allowed to be partisan. And concluded, of course, that, one thing we know from this is that readers don't like being told what to think. So regardless of whether it's ethically okay to do it, you know, it seems to have backfired somewhat in this particular instance. And I was going through my emails, and about 7 o'clock in the evening, there was an email that just said, hello. I thought, that looks quite friendly. I'll just open it and said, Siobhain, what a load of crap. So I sort of thought, that's not very nice. So I emailed back and said, Anthony, that was the person's name. I said, Anthony, I do hope, what a revolting email. I do hope this isn't how you conduct your discourse with other people in normal life. And then I looked him up, and he was a psychotherapist, which was really very odd. Anyway, he sent an email back going, I'm really sorry, I don't know what I was thinking of, I was drunk, it's 11 o'clock. But, people just, they don't realise that they're talking to someone, that when they comment on a column, or when they email me, or when they respond to each other, there are actually real people there. And one of the things I said in the article was, imagine that you go into work one day and you just take off your coat and sit down, and a gang of masked people come in and start telling you that you're really terrible at your job. Because that is what it's like for some journalists when they go to work and they log on to Comment is Free, which is the Guardian's biggest sort of commenting site, and that's what they see. It's tricky.
This is kind of a related question, and it has to do with the comments on the end of stories that are online. The so-called responsible journalists will write about public figures, private people, and may do it very responsibly, but of course the comments can be quite brutal and talk about people, name them, say things that are inaccurate or at least mean-spirited, unfair. Do you get a lot of complaints about that kind of thing from people who are meant because of the way they're mentioned in the comments? And do you have a thought about?
Are you talking about journalists commenting, or are you talking about
I'm talking
readers?
about private individuals commenting on stories and criticizing or being unfair to the people in the stories that the journalists talked about, wrote about.
Yeah. Well, remember that we don't have fantastic libel laws, so that's a concern in any event. The way it works is that when Commenters Free first started, everybody got very excited about being just so incredibly webby. How groovy was this? And the comments were not moderated, and that it was just sort of incredibly difficult. And as I say, people can be incredibly aggressive. So the website started to use moderators, and then there weren't quite enough moderators, and people got remember that we're a global publication, so the moderators are there from 9 to 5, and then people going a bit mad during the night when everybody's at home. So it's terribly difficult, but we now have a head of communities person, and if there's a column that's contentious, the moderators will look at that very carefully, but we post-moderate, so the stuff goes up, and it's moderated on the basis that it either breaches our top policy or it doesn't. It isn't moderated on the basis of ethical standards. It's simply, you're not supposed to be hurling abuse of each other. If you come onto this website, you've got to try and agree. There are endless complaints about people who say that they've been unfairly moderated, but because I think the website publishes something like 500,000 user comments a month, I say to people, go and exhaust your remedies elsewhere with this. Go to the head of communities, talk to her, and if you're still unhappy, then come to me. But there's no point in me trying to adjudicate whether or not someone's comment about Gordon Brown should or shouldn't have been taken off. I wouldn't go that far with freedom of expression. It's just a sense of proportion about it.
Hello. Do you, as an ombudsman, go back and look at crime stories where suspects allegedly did something, if they weren't convicted in court and so are innocent by our standards? Do you go back and then get rid of all of those stories online?
No. I mean, it's a similar point, and that's another thing that people say a couple of things about this. They say, I'm rehabilitated. That was a long time ago. But, I do think that open justice is a really important function, and in terms of the free flow of information and everything else. And I think newspapers have always been accessible in libraries, and notwithstanding this kind of problem of it being a very regurgitative medium, I think it's really difficult to interfere with some of those essential freedoms of expression, which are not about the journalist's freedom of expression necessarily, but about the public's right to receive information.
Just back to the archive issue again. I'm curious to what extent you pursue other websites that might archive your information, and how willing are you to tell them to take it down? And then specifically, I'd like you to comment on libraries. And, in the past, newspapers would go into the library and they'd stay there forever, and a newspaper wouldn't pursue the library and ask them to remove content.
Yeah, I guess in a way that's more of a kind of legal issue than a. So I'll put my legal hat on for that, but. It is possible, if somebody asks for content to be removed and it is something incredibly serious, then I will ask the website to contact Google and other search engines and remove all the cached copies. And you do your best. If you've made a really big mistake, as I say, the web really amplifies these things, that you really can't get rid of it. It does, the Guardian's a popular site, these things pop up very quickly for people. So if it's a huge mistake, I think you're under an ethical obligation to do whatever you can, as far as reasonably possible, to get rid of that content.
I know that it's rumored that journalists at the Star Tribune didn't want to be the subject of the Reader's Rep column on Sunday morning, and it's sort of an adversarial relationship at sometimes. What is your relationship with the journalists you work with?
Chilly. No, it's... Well, you're not going to be really, really popular. It's really difficult. The interesting thing is that, you write a column and the readers say, you've been really soft, and meanwhile, the journalists are going, you really hung us out to dry, how could you do that, So it's really difficult, but, no one's going to like it. No one likes being criticised. I mean, one of the things I find frustrating about that is I get a huge amount of criticism over everything I write, and from journalists internally. You know, my daily interactions can be quite negative sometimes. So I'm quite sympathetic to how they feel, but it's just the way it is. But, you know, it's easy. You know, a couple of people said to me, well, you could do this job and you could just become someone who's really hard-hitting and you could just, you know, but it's not about, you know, making a name for yourself as somebody who writes really hard-hitting columns. It's about kind of working out whether there's a huge error, working out, you know, whether the journalist has acted properly. And, you know, there are a few cases where the journalist hasn't. One of the things that is quite tricky is that my predecessor had this policy of not naming journalists. And I think, and somebody asked this question earlier about, you know, what have you done to kind of, you know, try and make this sort of more well-known to readers. You know, in newsrooms, I don't know what it's like here, but people have the most bizarre titles, you know, editor brackets, executive brackets, news, you know, brackets feature, something, you know, and some of these things just don't make any sense, and that's a problem with kind of anonymising content. And the other thing is that journalists don't like having things anonymous. You know, they'd rather have somebody on the record than off it most of the time. It doesn't seem quite right to me. But the biggest problem with it, I think, is that when I write columns that do take issue with the journalism, and mine is the only name on it, people start, and I'm critical, people start getting really cross with me. And I think in some ways it's a bit odd for me not to name people, and it's one of the things that I think, you know, I think about carefully, and a couple of times I have named the journalists who were involved because I just thought it made more sense to do it and couldn't really see any reason why not. But again, it's not going to make you hugely popular.
You talked about how in an era of self-publishing, pretty much journalistic privilege is extended to anybody who wants to. And my question is, do you feel like there's any possibility to kind of redefine how you define a journalist and, you know, maybe only consider the people invited to blogs like the Huffington Post or your blog, and to make it so we can still preserve some kind of journalistic privilege?
Well, I mean, I think the point about, I mean, you can imagine a scenario, and it can't be far off, whether somebody who calls himself a blogger and occasionally does some blogging for our Commenters Free website or the Huffington Post ends up with a disclosure of source issue. It just can't be very far away, and it is going to be, you know, I just don't know what the court's going to do with that. And I think that if they happen to have written that column, you know, when they were doing something for the mass media rather than on their own website, they might, or seem to be likely to get better protection. I mean, one of the sort of interesting things about disclosure sources, and I know there's somebody here, Patrick, who's done a lot of work on shield laws. One of the things in the UK and Europe is that these things tend to be, the court cases in the European Convention and the cases that flow from that tend to talk in terms of press freedom, journalistic privilege. So there's a whole kind of infrastructure there that's going one way, and you know, it's going to be hard for other people to get in. Will you just wait for the mic because they're recording you? So you have to, yeah.
Do you think it'd be possible to like implement any kind of like journalist license program or like something like this?
It's just such a dreadful idea.
What'd you say?
Sorry, that's just, it's, you know, that's even worse. I mean, why would you want to license journalists? I mean, for hundreds of years, the press has managed to, I mean, the thing about regulation, it's about state interference, and one of the things that the press needs to do is question government. So regulation is really, it doesn't really fit with press freedom very well. I mean, it's imposed on broadcasters because there are scarcity issues, and that's what you get. You have to agree to that in return to get your license. But the press has always resisted that, and I don't think the public, you know, are particularly interested in that either. And there's no benefit to the public in doing that. It just doesn't seem to me to be the way to go.
In your presentation, you stated 5 reasons why newspapers should not have ombudsmen. Yes. And one of them was the ombudsmen are boring as hell.
Yeah.
What are your defenses in support of ombudsmen for newspapers, knowing that newspapers are now eliminating the position of ombudsmen, apart from the defense of making clarifications and corrections, that is?
Well, why do I think they're necessary? Yeah, I mean, I think for the basic reason, and I sort of touched on this right at the beginning of the lecture, is that I think they increase reader trust and confidence. I think they would be less necessary if newspapers and media organisations were willing to own up to things. I mean, that's sort of the point of the lecture, But as long as people are not, and as long as people feel that they need somebody else to act as an interface, if you like. I mean, the other thing is that I think it's really important that newspapers are prepared to put their own work under the microscope. After all, that's what they're doing to everybody else. And it's a show of good faith, isn't it, to say, okay, we're asking everybody else to let us examine what they do and for us to write about it. And it's only natural, since newspapers are so powerful, that people might ask them to do the same. And I think that's a really important reason why you have an ombudsman.
Does The Guardian do anything to educate the public about journalistic ethics? And also, do you participate in many public discussions about these things there?
I mean, in a way, a lot of the columns I write are about sort of media literacy and journalistic ethics literacy. So that's really important. And one of the interesting things about having so many people reading us from other jurisdictions is that sometimes they get slightly confused about what we're doing ethically, because there are certain things that will fly perfectly well in the UK that would just not pass muster in the US. So one of the things that The Guardian does is it swears a lot, just absolutely potty-mouthed. And I think we use the F word because it's not that big a deal in England. We use the F word about 700 times a year and worse. And there are some rules about it. And one of the rules is it should be in quotation marks. And, in the sense that it should be a quote, I should say, so it shouldn't be used gratuitously. But of course, some of the best or some of the most popular columnists, use that, and they're absolutely loved by everyone. So it's a very irreverent publication in its lighter areas. So people from overseas just, they just write to me and just say this absolutely disgraceful. There's absolutely no need for this, and it's very difficult to bridge that gap and to say. We're actually quite relaxed about this. We're not particularly relaxed about violence, nudity. We're sort of slightly more relaxed about, and so all of these sorts of things have to be explained to people that they're not. We don't have a kind of. We don't have a bit of the code that talks about whatever you do, don't be too offensive. I mean, journalists are asked to take that into account and to have justification for using swearing, but it is. It's difficult to explain. So I think that's an important part. The other thing is that lots of readers in the US can't understand that the UK press is not hung up on objectivity. So we don't do he said, she said journalism. It doesn't mean to say that the reporting is not fair and balanced, and that it's not necessary to get comment. And there are plenty of instances where I would criticise the newspaper if a news report didn't include comment, but it's not compulsory. So readers from overseas just say things like, you've got, that doesn't look right to me, you haven't got their side. And when you get to issues that The Guardian campaigns about, like environment and climate change, and there's one particularly sort of campaigning journalist who writes against homeopathy, it's really problematic. I mean, it's a bizarre situation. I think Geneva Overholser mentioned this in her lecture 4 years ago as well, that, if you have he said, she said journalism, and you take an issue like climate change and you give equal space to the counter-argument, it's not really doing anything to get to the truth of a matter. So, those things all have to be explained.
I'm curious about...
I can't see you, where are you?
I'm right here.
Okay.
I'm curious about, once you started documenting all these corrections that are coming in, if you consistently see corrections in one particular part of something that The Guardian has going on online or in print.
Sure. There are a couple of areas. I mean, readers really complain about quite small things. I mean, they're in very large numbers. So numeracy, journalists are terrible at numeracy. And I notice when I look at Regret the Error, which is a sort of a corrections website that some of you might know, that US newspapers seem to have the same problem with numbers that British newspapers does. So numeracy just drives people absolutely loopy. If we can't get those numbers right, so we frequently correct those things. And I've written a couple of columns about that and recommended that journalists should be trained in numeracy. So there's that. The other issue that's very difficult at the moment is how many people died in Iraq, how many people have died so far as a result of the invasion of Iraq. And, you know, you just can't win with those numbers. It's a really incredibly difficult thing to do. And we've published a couple of corrections, and I've written a column about failure to quote your source there. I mean, use a figure by all means, but say it's the Lancet inquiry, say it's the Lancet research, and say what that research represents. Because people get very offended if they think you put the figure too high or too low.
Hi, I'm over here,
Where?
far to the right.
Okay.
Hi. What you said about, you know, popular views of ombudsmen as being very, you know, maternalistic, paternalistic, kind of rang very true with me, because I've seen a lot of investigative reporting that I liked almost being neutered by ombudsmen in the past in the United States. And I was wondering if there's like a fundamental difference in the way that an ombudsman functions in a partisan news environment as opposed to over here where we try to have like the, you know, the veneer of objectivity.
Yeah. One of the articles I wrote this year, I get a lot of lobbies about particular issues, and you know, lobbies are sort of by their nature very polarized. And one of the lobbies that I got was your correspondent in Venezuela is putting far too much opinion into his news coverage, you know. But it's Hugo Chavez. I mean, what are you going to do? You know, he has a Sunday show where he, you know, talks to people on the beach all day on television, and that's, you know, part of his sort of political campaigning. He does quite strange things. So I ended up saying, I actually think as long as readers can distinguish in that kind of reporting between the journalist's opinion and the facts, I don't have a problem with that. So, you know, that's my view on that. Investigative reporting, I think, is really difficult because, as that Wall Street Journal case showed, and that was kind of what I was trying to show, that you know, sometimes you don't have all of the pieces in place. I mean, Aitken was a fantastic case, but in the UK, newspapers have the burden of proving what was true in the libel action, and we don't really know to this day we don't have all of the pieces in that jigsaw. And there were two of the pieces in that two allegations in that litigation that we were doing very badly on. And I remember going to a conference with George Carman, who was a very famous libel QC at the time, and Granada TV were in the room at the same time, and they had insurers with them. And The Guardian has always shunned libel insurance on the basis that we don't want insurers telling us how to run our lives, so it's self-insuring. So the insurers were getting very edgy, and they said to George Carman, well, you know, what chances of success have we got in this case? You know, and he said about 5%. And for some reason, there were a lot of documents in this case, and there was no jury, which is quite unusual in a libel trial in the UK. And throughout the time that Aitken was lying in the witness box, the judge was just making notes. He just wasn't looking at it at all. And, you know, it was a very frustrating thing. And what happened at the last minute. One of the journalists went over to a hotel. The hotel had closed down. He found a receipt that proved that Aitken wasn't where he said he was. It then transpired that Aitken had, we were able to conclude from that Aitken had got his daughter to falsify a witness statement. And that's how those pieces fit into place. And that experience makes me worry about being too rigid in these views of responsible journalism. And that's why I think these kind of lists are okay from some perspectives. There's some, you know, you look at the lists and you think, well, don't disagree with that, not so sure about that bit. But actually, I think that kind of C.P. Scott approach, where you look at the brand values, the values of the newspaper, keeping comment and opinion separate, I think they're much more important in some ways than sort of checklists of, did you do this, did you do this, did you do this, did you do this? That's not necessarily, I think, good journalistic ethics. It's, you know, I think each case has to be sort of designed from its merits, and I think those responsible journalism cases are useful for showing that there are some circumstances and when it's okay for journalists to get things wrong, you know, as long as they've acted responsibly. Okay.
Thank you, Siobhain. And now I would like to invite all of you to join us in the lobby for light refreshments, hopefully Coke that is not flat, and more conversation. Please take a moment to pick up a copy of the Silha Bulletin and to fill out one of the comment cards on the table outside the auditorium. Let us know if you'd like to be added to our mailing list, and be sure to visit the Silha Center's website to learn about our upcoming events, including our 24th annual Silha Lecture in 2009. Please join me in thanking Siobhain Butterworth.